India's criminal law was governed the code born in the colonial era. Why did India finally replace it? Let's uncover the story behind this historic legal transformation. Imagine living under a law written before the invention of the telephone, before airplanes filled the skies, before computers, the internet, cybercrime, or artificial intelligence even existed. Yet for more than 163 years, India's criminal justice system was built upon a legal code drafted during British colonial rule. How did the law created for an empire survive into the 21st century? And why did independent India finally decide to replace it? This is the remarkable story of India's biggest criminal law reform since independence. In the middle of the 19th century, British India was governed by hundreds of different legal customs and regional regulations. The colonial administration wanted one uniform criminal law that could be applied across the country. In 1834, the first Law Commission was established. Its chairman, Thomas Babington Macaulay, led the preparation of a comprehensive criminal code inspired by English law but adapted for colonial India. After years of revision, the Indian Penal Code came into force in 1860. Containing more than 500 sections, it became one of the world's most influential criminal codes and was adopted wholly or partly by several countries. When India became independent in 1947, the Constitution transformed the nation into a sovereign democratic republic. Yet the Indian Penal Code remained. Over time, Parliament amended many provisions, and the courts interpreted them to meet changing social realities. But the basic framework of the law continued to reflect the colonial era. As decades passed, India changed dramatically. Technology revolutionized communication. Cybercrime emerged. Digital evidence became central to criminal investigations. Organized crime networks expanded across states. Financial fraud became increasingly sophisticated. Terrorism presented new security challenges. Citizens demanded faster investigations, stronger protection for women and children, and a justice system better suited to a modern democracy. Many legal experts believe that criminal laws needed comprehensive reform rather than piecemeal amendments. In 2023, Parliament passed three landmark criminal law reforms. Bharatiya Nyaya Sanhita replaced the Indian Penal Code. The Bharatiya Sanhita replaced the Code of Criminal Procedure. The Bharatiya Adiniyam replaced the Indian Evidence Act. These reforms came into effect on July 1, 2024, marking a new chapter in India's criminal justice system. The Bharatiya Nyaya Sanhita introduced several significant changes. Community service became a punishment for certain minor offenses. Organized crime and terrorist acts received clearer statutory recognition. Mob lynching resulting in death became a distinct offense. Provisions addressing crimes against women and children were strengthened. The law also incorporated offenses committed through electronic communication and digital technology more explicitly. The Bharatiya Sanhita sought to modernize criminal procedure, electronic filing of complaints, greater use of digital records, video conferencing, forensic investigation for specified serious offenses, and timelines for various stages of investigation and trial were introduced with the objective of improving efficiency and reducing delays. Meanwhile, the Bharatiya Adiniyam recognized the growing importance of electronic and digital evidence in criminal trials. Emails, mobile data, CCTV footage, digital records, and other electronic evidence gained a clearer statutory framework within the law of evidence. Supporters describe these reforms as an effort to decolonize India's criminal justice system and adapt it to the realities of the 21st century. Critics, however, raised important questions regarding implementation, interpretation, civil liberties, and whether legal reform alone can solve systemic challenges. Like every major legal transformation in history, these new laws continue to be studied, debated, interpreted, and refined through judicial decisions. One principle, however, remains unchanged. Laws are not merely collections of sections and punishments. They reflect the values of a society. From the Indian Penal Code of 1860 to the Bharatiya Nyaya Sanhita, they India's criminal law has evolved alongside the nation itself. The journey from colonial legislation to modern legal reform is not simply the story of changing statutes. It is the story of a democracy constantly striving to deliver justice more effectively. And that journey is still from the IPC to the Bharatiya Nyaya law has entered a new chapter. But one question remains: can new laws deliver better justice? The answer lies in how we implement them.